So, Ryan, if you would tell me why somebody would be interested in hiring an attorney to conduct a transaction, because oftentimes people in Florida simply do the transaction through a title company.
Yeah, so obviously in Florida, we have a lot of folks relocating from other states, other countries, which is even more common in this climate. So we do have a lot of explaining to do about the differences between states, because there are vast differences. Some states, the real estate attorney drives the bus on the transaction. Others, it's non-attorney title companies. And even frankly, folks that are Florida residents have confusion about that. In the state of Florida, the way it works is that if you're closing a transaction, you have a choice. You can either choose a real estate lawyer or firm, or you can use what I call a non-attorney title company. The distinction is that at the end of the day, the goal, the end goal of using either is to get the transaction closed. However, a non-attorney title company is there to close the transaction and does not have a client. They are ethically and legally limited to what their scope of representation is, which is really essentially, for lack of better words, representing the transaction. They can't be a legal advocate for either party. They are there to, close the transaction, issue the title insurance, do the documentation, hopefully correctly and competently. However, neither party has actual representation. Now, a lawyer or a law firm that's involved in the transaction does have a client. We are ethically and legally bound to have a client. The client is typically the party that is paying for our representation. So in the contract, obviously, it's clearly spelled out which party to that transaction is selecting the closing agent and paying for those services. That typically, obviously, is the client. When we send out letters at the initiation of a transaction, we define the scope of our representation and clearly define who or what our role is, I should say, to both parties. If a buyer selects us to represent them in the transaction, not only do we close the transaction like a non-attorney title company, but we represent that buyer in the transaction. So should there be any issues related to title, related to survey defects, related to anything, we will represent the buyers as their advocate and ensure that their rights are protected, that their deposits are protected, and that the transaction closes in accordance with the contract. If there's survey defects, title defects, we will timely object on behalf of the buyer regarding that. A non-attorney title company cannot do that. If there are title defects or survey-related defects, the non-attorney title company has a duty to disclose those, but they cannot take a legal position on behalf of either party. They would have to refer that person to an attorney in order to do that. The other huge misconception between the two is that a lawyer either charges more or is going to kill deals. On the issue of cost, that is a complete misconception. Matter of fact, I've been doing this 16 years. I've seen many non-attorney title company title quotes or closing statements where the fees were substantially more than what our firm charges, for example. So the reality is that if you select a lawyer, you're really paying the same, many times less than what you might pay for a non-attorney title company, but you also get the benefit of having that legal representation.